Yes, good evening. Just before you take the podium, I think we needed to clarify something arising from the scrutiny. Justice Renaura will do so.
The Chief Justice, Counsel, the two processes are going on well, both at Forodha House and at IBC. Whatever issues are being raised by parties are being addressed by the two teams. I suggest we let them proceed, and then again we can revisit any arising issues tomorrow morning. But so far, both our teams are saying the process is ongoing. We should not trouble ourselves for now. Thank you very much, CJ. Thank you, Counsel.
Yes. Okay.
Chief Justice, Deputy Chief Justice, Your Ladyship, my Lords, Justices of the Supreme Court, my address will be followed by Apollo Boya, who acts for Cherera, the Vice Chair, followed by Jotham Arua, who acts for Commissioner Justice Nyangaya. He'll be followed by Jeremy Jenga, who acts for Commissioner Francis Wanderi, followed by Gordon Ogola, who acts for Commissioner Irene Masit, and then finally Mansu Issa, who will address the court on behalf of the four commissioners collectively, as I will be addressing this honorable court on behalf of the four commissioners collectively.
So are we giving each one of you 10 minutes? Or within the 1 hour? So we
yes.
put there 1 hour?
Yes, we'll distribute amongst ourselves. Yes. We hope to do it within that 1 hour. Your Ladyship, my Lords, the first submission, fundamental submission I'd like to make is that when this honorable court retires to consider the judgment it will deliver, this court be guided by the fact that it is the position taken in this court by the four commissioners, being a majority of the IEBC, that should inform this court's decision, not the views of the minority. The official position of the Commission is as per the views and affidavits of a majority of the commissioners. And that has to be so in law, the reason being that under the Constitution, and in fact under the statute, the IEBC is a corporate entity. Therefore, in the absence of consensus, its decisions as an institution are by the majority. So do not depart from that principle, a principle that has found judicial anchorage and recognition in a number of decisions cited by my colleague Paul Mwangi, the minor KI decision, the Michael Kamau case, and the other decisions. Corporate decision, and that position has been addressed, and I do not want to take the time of the court by going through it again. With regard to each one of these four commissioners, I ask this honorable court to bear in mind that each one of them went through a very rigorous vetting by the National Assembly, at which there was full public participation before they got appointed, so that anyone who had any issue with any of them, that was the time to raise the issues. Again, the law is clear about how one can complain about a commissioner enjoying constitutional security of tenure. So do not be influenced with innuendos and insinuations about these 4 commissioners. They were vetted by the people's elected representatives. Now, coming specifically, this is the second fundamental submission I'd like to make. This so-called walking out from Bomas. Look at the affidavits of the 4 commissioners. The vice chair saw 2 affidavits, so there are 5 affidavits in total. And I invite this honorable court, when it retires, to read through those affidavits in their entirety. We adopt them. We rely wholly on the averment in those affidavits. And you will find in those affidavits that all that these 4 commissioners were demanding of the chair at Bomas at the tail end of the tallying and the verification. Their narrative, which I invite this court to accept, is that they were not involved in the tallying and verification, and in particular regarding the 27 constituencies. So they were demanding of their chair, you cannot bring a paper here and tell us that these have been verified and tallied by the chief executive. The work of the chief executive is to implement decisions of the commission. He is not part of the commission, any more than the registrar, the chief registrar, implements, or any registrar of the High Court, implements the decision of the judges, not the other way around. So they were saying, we need to tally and verify the results in respect of these 27 constituencies. And the chair would not allow that, which was typical of the relationship between the chair and these 4 commissioners. And a twist is being given that it is these 4 commissioners that wanted to force a runoff. It is the exact opposite, your ladyship and my lords, and that is what we state in the affidavits. It is them who were asking, how do we confirm that the candidate you are about to announce has received 50 plus 1 votes? And his response was, are you trying to force a runoff? I am not conducting another election. So this acrimonious relationship is what was there between the chair and his 2 allied commissioners and the other 4 commissioners. Now, I would like to submit that the 4 commissioners were fully justified in saying we cannot own results we have not tallied and we have not verified. The law has been referred to this honorable court severally that it is the commission that should do the verification and the tally. This legal notice that appointed the chair as the returning officer, you've been invited to hold that legal notice, that regulation is unconstitutional and valid because it contradicts the Constitution and the Elections Act. But beyond that, it is the chair himself alone who appointed himself as the returning officer for the presidential elections. You will not find any minutes of any meeting by the commission appointing the returning officer. So quite apart from the fact that it was unconstitutional, it did not have the authority of the commission. I would like to cede ground to my colleague Apollo so that we operate within the 60 minutes accorded to us. I ask that this court upholds the position of the 4 commissioners, that the results that were announced were not the results tallied and verified by the commission. I thank you.
The Chief Justice and members of the court, without wasting more time, I'll pick it up from where Senior Counsel has left. My name is Apollo. I am on record for the fifth respondent. Your Ladyship and my lords, the actions of the chairman of the Electoral Commission can be evaluated using several instruments. And I believe the first instrument that we need to use in examining the whole issues that are before this court is the oath that the commissioners take. The oath is in the 3rd schedule of the IEBC Act, so that for every action, we juxtapose that oath to those actions, so that we test if the actions meets the tenets of that oath. And permit me to read what that oath says, and it's taken by all the commissioners. It states, I, then they say their name, having been appointed chairperson or member, as it can be, of the Independent Electoral and Boundaries Commission, do solemnly swear that I will at all times obey, respect, and uphold the Constitution of Kenya and all other laws of the Republic of Kenya. That is the oath they take. That I will faithfully and fully, impartially, and to the best of my ability, discharge that trust and perform the functions and exercise the powers devolving upon me by virtue of the appointment without fear, favor, bias, affection, ill will, or prejudice. That is the promise that they are giving to the people of Kenya and to the whole world. Now, for every action that the chairman did, which I'll not go into because this particular affidavit of the 5th respondent has been cross-referenced by my other senior counsel and also learned colleagues who spoke before me. We juxtapose those actions against that oath that they took. So, for example, if we are talking about issuing a gazette notice, you look at that gazette notice with the law, then juxtapose it to the oath, if it meets that promise that they gave. Your Ladyship and my lords, the 5th respondent is now affectionately called opaque. Affectionately. I say that because arising out of what transpired at the National Tallying Center, the 4 issued a statement in which they said they cannot own the results that were going to be announced by the chairman, and therefore they were opaque. Your Ladyship and my lords, that term opaque is not coming from the ordinary. It's a term that was given by the Court of Appeal when they were making a decision In another matter, which is now famous here, called the Maina Kiai matter, which when they were looking at the role of the chairman vis-a-vis the other commissioners, and the court did indicate that to suggest that one individual alone can tally and verify the votes for presidential election is to suggest otherwise, to introduce opaqueness and arbitrariness to the electoral process. Those were the words of that court. Members of the court, we might ask if the chairman, as indicated from the affidavits that we have had, that it was his responsibility alone to tally and verify the results. Then the question is, what were the other commissioners supposed to be doing on that election day? Were they supposed to sit at home and watch the screens just like any other Kenyans? But then again, the chairman went ahead and allocated them duties. With respect to the fifth respondent was given the role of media. In that role, the fifth respondent was supposed to explain even to the media why what they were reading, the results they were reading, are not being projected on the screens. The results that they read were not projected from Friday 13th. And when that question was put to the chairman to refresh, the chairman said, no, I'm tallying from the back end. Your ladyship and my lords, the sum total of this whole transaction is that the chairman usurped the powers of the commission. And it's our submission that after all is said and done, and after we get the reports of the verification, I believe that this court will arrive at a conclusion that the chairman of the Electoral Commission was actually an agent of a presidential candidate. That presidential candidate we will know by 5th of September. And if that's going to be the case, lastly, it's our submission that this court must go further and look at the theory of agency. All the conspirators that did any illegalities, all irregularities, are agents of one another. The person who benefited from those irregularities and illegalities is a co-conspirator with the persons who perpetrated it, and they are agents of one another. And for that reason, we would urge that this court makes appropriate decision with that particular issue in mind. I call upon my learned colleague, Jotham Marua, to take over from me. Thank you very much.
The Honorable Chief Justice and the honorable members of the court, my name is Jotham Marua. I appear for the 7th respondent, Commissioner Justice Nyang'aya. I will be making submissions on the following issues. Issue number 2, whether there was interference with the uploading and transmission of Form 34As. I'll also speak to the issue whether there were irregularities and whether the irregularities affected the results. I'll mention briefly something to do with the reliefs that this court ought to make, and also issue number 6, whether IBC carried out the verification exercise. So on the first issue, my lady and the honorable members of the court, the position of my client is that there were indeed interference with the uploading and transmission of Form 34As. My client maintains that this was done without the involvement of the commissioners, specifically the 4 commissioners. And it is their position, my lady and the honorable members, that it was done in clear violation of Article 81E of the Constitution and Article 86. Before I proceed, I wish to clarify that we have made reference to a number of authorities in our written submissions, but I will not refer to them because of time constraints. As regards interference with the ICT infrastructure, the Commissioner, in his affidavit, which has been filed before this court, and specifically in paragraphs 33 to 34, raises a number of issues. First, he maintains, my lady and the honorable members, that the server was accessed by unauthorized persons, and these included foreigners and some members of the IEBC. He mentions them by name. He further maintains that one foreigner by the name Gudino Omar accessed the server several times. He explains that a number of forms were pulled down and others uploaded. And he also maintains that there was revision of Form 34Bs. My lady and the honorable members, these allegations are contained in his affidavit, and I wish to point out that they have been responded to by IEBC. In their response, the first thing I wish to point out is that there is no denial that the logs that he annexed to his affidavit emanated from IEBC. The only contention being raised is how did he get them? That contention, in our humble submission, has no merit, considering, as he puts in his affidavit, that he was the commissioner in charge of ICT at the commission. If a commissioner who is in charge of ICT cannot access that kind of information, it is my submission that nobody else in IEBC can access them. The next thing that, and that admission, Madam Chief Justice and the honorable members, is found in the affidavit of Hilda Kavonga. That affidavit is filed by the firm of Iseme Kamau and Maema Advocates and is sworn on 27th of August 2022. And the admission is contained in paragraph 13, Roman 4. Beyond that, Madam Chief Justice and the honorable members, there is also an admission, and this, according to me, is a serious admission. There is an admission that the server was accessed by a foreigner by the name Gudino Omar, as mentioned in the affidavit of Justice Nyang'aya. But I wish to read to the court what is said as concerns this foreigner. At page 5, paragraph 13.7 of her affidavit, that is Hilda Kavonga, she says, Gudino Omar is the technical lead for Smartmatic, who provides support on the technology provided by Smartmatic. He's the technical deployment lead, and then in paragraph 8, she continues, they said Gudino Omar, being a technical deployment lead, his role is to deploy infrastructure, that is networks, server platforms, and services. In his capacity, he is supposed to have access to the said infrastructure to monitor by ensuring the system is properly running at all times. Now, the first point that we need to bear in mind, Madam Chief Justice and the honorable members, is, did IBC formally gazette Gudino Omar as one of the persons who had access to the server? Secondly, IBC is enjoined under Article 81E to uphold the secrecy of the vote. How secret can the vote be if it is being constantly accessed by a foreigner from a distant location? What is the guarantee that this foreigner will not grant further access to other unauthorized persons to commit all manner of mischiefs? But more important, Madam Chief Justice and the honorable members, is the complaint by Justice Nyang'aya that Gudino Omar was uploading and downloading forms. There is silence with regards to that issue. Then there was the contention that other unauthorized IEBC staff also had access to the server. And their names were provided, Madam Chief Justice and the honorable members. In the replying affidavit by Hilda Kavonga, again they make this admission, and with respect to one Abdidahir Maalim, it is argued, and I'm referring the court to paragraph 13, Roman 6 of Hilda's affidavit. She says, Abdidahir Maalim was a returning officer, and this access was limited to transmitting Form 34Bs and not to any other function. Madam Chief Justice and the honorable members, the list of all the returning officers, who participated are included in the affidavit of Juliana Cherera, and specifically marked as Annex J C2. Unfortunately, the name of Abdidahir Mohammed does not appear. It is not indicated with respect to which constituency or which county he was the returning officer. It would appear clearly that there was a lie. Beyond that, the logs that were filed by Justice Nyang'aya were also analyzed by a forensic analyst, George Njoroge. And he submitted an affidavit to which he annexed a report. And in that report, Madam Chief Justice and the honorable members, it is clarified that Abdidahir Mohammed accessed the server more than 1,000 times. The question one would ask is, why would he access the server so many times? What was he doing? Madam Chief Justice and the honorable members, it is quite clear that the server was defiled. The next issue I would wish to speak to, and I can see I'm having serious time issues, is whether the IBC verified the results. And it is my submissions that that did not happen. And I'm saying so for two reasons. First, and this is important because it's not been captured by my colleagues, according to the Constitution, it is not only verification by IEBC that is required. Verification is supposed to happen at two levels. First, by IEBC, but secondly, by Kenyans. That's why both Article 86 and Article 81E institutionalize transparency. IEBC should make sure that every processes that they are undertaking are laid bare for the public to see, so that the public can also follow the processes and undertake their own verification. For reasons that have already been explained, it is clear that this verification by the public was not possible due to the opacity that has been referred to by my learned colleague, Uphold. But then there is the issue of verification by IEBC, which also did not happen and could not happen given the circumstances of this matter. Madam Chief Justice and honorable members, you have been told how 4 IEBC commissioners were sidelined in the entire process. It is our submissions that it could not have been the intention of Kenyans that IEBC commissioners be reduced to spectators in a presidential contest. That is something which is inconceivable. And we would humbly urge this court to put a stop to this practice. There are other issues that I would have wished to deal with, but because of time, allow me to cede the floor to my colleague, Jeremy. Thank you very much.
Yes, my Lady the Chief Justice and the honorable members of the court. My name is Gordon Ogola, and I'm representing the sixth respondent, that is Irene Masit. My Lord, I'll rush through my submissions because I don't want to give more time to my brothers. I've been sent here by the sixth respondent to tell the court and the whole world that she's not coming here as a second-tier petitioner. She's not coming here as a surrogate of anybody, but she's coming here as a demonstration of her undertaking to protect, uphold, and defend the integrity of the Constitution. Indeed, while taking oath of office, she undertook to carry out her duties in compliance with the Constitution. In that regard, the sixth respondent was alive to the fact that in conducting the general elections, they had to be guided by the provisions of not only Article 81, 86, and 138, but also Article 10 of the Constitution. My Lord, the sixth respondent submits that the manner in which the election process was managed by the fourth respondent, up to and including the tallying, verification, and the declaration of the results, flies in the face of the provisions of the articles that I've cited. As will be seen in the affidavit of Irene Masit and corroborated with the affidavits of the other former commissioners, the chairperson excluded the majority of the commissioners from the tallying and the verification process. In fact, if you go through the affidavits, you will note that the only duty that they were assigned or that they undertook as regards verification and tallying was when they were summoned by the chairperson to be given the results in the office. My Lord, and the other thing that they only did is after he told them, this is the results I'm going to read, was to give them the Form 34C. They did not take part in the tabulation of what resulted in Form 34C. My Lord, the sixth respondent had a legitimate expectation that as stipulated under 138(3)(c, that the tallying and the verification ought to have been done by the commission and not by an individual commissioner in the person of Chebukati. In fact, the exclusion of these commissioners did not start at that point while they were in Bomas, but it started at the point when he, Mr. Chebukati, unilaterally reassigned them duties that they would take at the floor of Bomas, which were completely at variance with the duties that they were holding as in the subcommittees that were running at the commission. My Lord, before the declaration of the results, the commissioners were expected to ascertain and satisfy themselves that whatever was being put into 34C was a true reflection of the contents of 34A and 34B, but they were never given that opportunity. My clients and the three commissioners have confirmed that they were not involved in the process at all that gave birth to 34C. My Lord, even during the declaration of the results done by the four commissioners, evidence that can be found in the affidavits shows that the only things they were given were handwritten pieces of paper with results in them. Those documents that they were given and which they were reading out to the public are not part of any accountable documents that can even be brought to this honorable court. Secondly, at the time of the declaration, my Lord, you will note that there were 27 constituencies whose results had not been verified. Even though the chairperson claims that they could not announce or declare the results of those 27 constituencies because of the chaos that erupted, but they had an opportunity again when things were calmed down and they came back to declare the results of the presidential elect. Can it therefore, my Lord, be said that the process that led to the declaration of the results were transparent, were accountable, or were verifiable if indeed the declared results were accurate? My answer and the answer of the sixth respondent is in the negative. In respect to my client's position as to whether she accepts or agrees with the results that were announced, at paragraph 73 of her affidavit, she states that without verification of results from the 27 constituencies, I believe it was not possible to determine a winner in the hotly contested 2022 presidential elections, and to that extent, I cannot vouch for the veracity of the result declared by Wafula Chebukati on the 15th, for there was no transparency on his part towards the declaration of results and final figures and were not verified. I was kept in the dark by the chairperson with respect to tallying. That is her position. She cannot vouch for the results that declared William Ruto as the president-elect. My Lord, lastly, the conduct of exclusion by the chairperson of the other commissioners from vital activities of the commission was not limited only to the events that happened at Bomas. I will just cite a few. One of them was the manner in which he assigned the commissioners' roles to play at the Bomas. That was a unilateral decision. Secondly, the unilateral deployment, transfer, and gazettement of returning officers nationwide. That can be found in the affidavits of the sixth respondent at paragraphs 16 and 17. Then the third one is the deliberate failure to facilitate the contract implementation committee to oversee the implementation of the ballot papers, contracts, and task of inspection of the printed ballots at the vendor's factory in Greece. That is a function that ought to have been done to ensure that there was due diligence of the ballot papers that were being printed. That one, again, they were not involved, and that did not take place. Lastly, second last is the postponement of the elections in specific areas, including Mombasa, Kakamega, Kacheliba, Rongai, Pokot, South, among others. And lastly was the appointment and gazettement of the chairperson as the national returning officer. That, again, is not a decision that was taken by the commission unanimously. My Lord, in the end, it is apparent that in managing the affairs of the commission with regards to the elections, the fourth respondent as the chairperson deliberately created a dysfunctional system to aid and abet his criminal and evil acts that would be interpreted to mean that he had intention to subvert the sovereign will of the people of Kenya. We beseech you, therefore, to find that nothing good can come out of a dysfunctional body. I'll therefore call my friend Jeremy to continue.
Yes, my ladies and my lords, I'll be very brief. My learned friends have touched most of the issues. My name is Jenga Jeremy, appearing for the eighth respondent. I want to give time to my learned friend Issa Mansour. So just a few points for clarification. One, speaking for the eighth respondent. My ladies and my lords, the eighth respondent per se, because of his position, is still a commissioner with the IEBC. He does not want to be classified as opposing or supporting the petition. But the reality is this, that by him, and I think that's the position of the other, from the fifth to the eighth respondents, by telling the court the truth, by telling Kenyans the truth, what happened at IEBC before the elections, during the elections, and after the elections, by telling the court the truth, unfortunately, they have no apologies for this, that evidence addresses some of the issues that have been framed by the court. One of those issues that, according to the eighth respondent, is addressed by his position, the one that is taken in his affidavit, is issue number 6. That is whether the IEBC carried out the verification, tallying, declaration of results in accordance with Article 138. My learned friends have covered that. The eighth respondent's affidavit has covered that. They were not involved in the tallying verification. So answering that question, the eighth respondent, it is his position that the presidential elections that were announced by the third respondent did not comply. Now, the other issue that I want to clarify, my ladies and my lords, or maybe I should address whether the issue number 1, 5, and 7. Again, because of the peculiar nature of the way the IEBC is run by the chairman, it is the eighth respondent's position that despite being a commissioner, he cannot even help the court in addressing those issues because the results that were announced on the 15th of August, the system that had been put in place, the person who was in charge of them, it was not the commission, it was not IEBC, but that is the chairman. The chairman is the one who can be able to answer most of those questions. The results that were announced, his position is that those were not the results of the commission, those were the results of the chairman. Maybe the other issue that I should mention is that the 5th to 8th respondents, they've been branded all sorts of names. Some of them appear in the documents that are before court. Others have been mentioned out there. And my Lord, what the 5th to the 8th respondents did by walking out of Bomas is because they did not want to give legitimacy to a process which they were not involved in. My Lord, by taking my ladies and my lords, by taking the position they did, as has been mentioned by my learned friends, they took an oath of office. And the oath of office that they took was to uphold and protect the Constitution. When they realized that the Constitution was being abused, their role that they were supposed to play was being abused by the chairman of the commission. That's why they took that position. Did they take that position so that they could support any of the parties? My Lord, that is not the position. They were just exercising their right, what they had taken oath to do, uphold and protect the Constitution. So all these names, the way they are being seen, that like they are taking sides, they are not taking sides because they had any interest in the outcome of the elections. They took the position they did because they wanted to uphold the Constitution. My ladies and my lord, we have there are some authorities in our list of authorities that we would kindly request that you look at them. I know you've been referred to authorities within Kenya. We have gone out of the country. We have some very good authorities from India, the Supreme Court of India. I will not take time to go through them, but they will be of great help to the court even as you retire to come down with your judgment. My lady, because of constraints of time, I will leave the remaining time to my learned friend, Mr. Issa.
Good evening. My Lady Chief Justice, the Deputy Chief Justice and Justice of the Supreme Court. My Lords and my ladies and my lords, in summarizing the position of the 4 commissioners who are now respondents in this consolidated presidential petition, Lords, we want to make the following submissions. One, as a commission, it is the position of the 4 commissioners that they did what was within their mandate to deliver a free and fair election as required by the Constitution. But in their quest to do what is right, what is required of them, there are problems that have been set out in the respective affidavits. And my lords, the first issue that you would note that springs from these 4 affidavits by the 4 commissioners is a question of lack of transparency. On the day after the voting ended, and also predates the general elections. You'd note one thing that is common and that cuts through the 4 affidavits is that they were excluded from the process that was going on in terms of verification. And what is clear when you look at all these 4 affidavits is that yes, there was that process where they appeared to read results. These results, and they've said this under oath and has not been controverted, were the results that were being processed on the floor of the National Tallying Center. They were handwritten. And that's important because they were handwritten. They would come out and read them to the agents and to the nation so that for each and every constituency, and these results were per constituency, people would know that these results have been verified at the National Tallying Center. You would note that in this affidavit, for the first 2 days, from the 9th to the 12th, these results were being posted or they were being aired in a screen that was available to the agents, the presidential agents, and to the media. That screen was paused or it went off. In all the affidavits, they said and they requested that this screen should be on so that as we go progressively verifying and tallying the results, anything we announce here can be confirmed by both the presidential agents and by the voters who voted. That request was declined. The question is why? Why did the chairman refuse to put on those results and to verify the numbers that were being read to the nation? The second question that you'll see that arises in terms of the process of verification and tallying, that has been covered by some of the parties that have submitted today. You'd note that when that process reached the tail end, the 27 constituencies that had not been announced had not been publicly confirmed to have been verified. And in fact, when you look at the affidavit of Commissioner Wanderi, he says he had taken a break because he had been there overnight. When he came back, the first expectation was that these results would be confirmed, they had been verified, and that they had been announced to all the agents. The chairman takes the position there was no constitutional requirement or he had no legal requirement to do that. No, he had. Because the Constitution requires transparency and accountability. That is the process that takes place at the National Tallying Center. It is not a perfunctory exercise. It is not a ceremony. It is a constitutional process. And why this is important is that the document that was given to the commissioners by Mr. Marjan, as confirmed by Mr. Chebukati, was not a Form 34C. That was being undertaken not by the commissioners, but members of staff in the back office of the chairman. The commissioners did not see Form 34C, did not verify it, and they did not approve it before it was generated. In fact, in all of their affidavits, they said they never saw the Form 34C. What was given was a 3-page document, and that document has a problem. That document appears in the vice chairman's affidavit and the other 3 commissioners' affidavits. What you note about that document, and that was generated by Mr. Marjan, as has been confirmed, and presented to the commissioners, is a summary of 47 counties. It does not have the results that are required to be confirmed and verified at the National Tallying Center of the 290 constituencies. Why is that important? Because at this point in time, before the Form 34C can be generated, these 7 commissioners, and I'm talking to them as a commission, needed to verify that what we have announced before the nation and to the presidential agents these are the results that have been announced publicly, and this is what has been tabulated for each and every constituency, and these are the results garnered by each and every candidate. And on the basis of that, then a Form 34C is prepared. That 3-page document is not a Form 34C. That is a document that the chairman came with, or he was presented, and then he went and declared the result. That was unconstitutional because the Form 34C needs to precede the Form 34D in terms of the commissioners approving that document. And because that is their role, that is a constitutional role. In fact, we engage these commissioners. We invest the billions that we invest in the commission so that when this solemn exercise comes along every 5 years, that process, they take it seriously and they do it in accordance with the law. And the third issue about transparency. The commissioners were not aware of how many voters, and that figure was not confirmed at the time this figure was being given to them. The figures, and you'd note about the different figures that have been given, and in fact, I was asked to highlight this. When you look at the affidavit of Mr. Sonkuli, sorry, let me start with the chairman, Commissioner Chebukati, at paragraph 30 of his affidavit, the one that he saw, sorry, on the 26th of August. This is the one that has been prepared jointly by the firm of Gumbo and Company, my good friend. At paragraph 30, he gives the percentage 64.6. In Mr. Sunkuli's affidavit of the same day, and I know that an explanation has been given. On the 26th of August, at paragraph 25, he says at the close of voting that the turnout that had been reported in Kimskits was at 63.6%, and he gives the figures. Now, the commissioners needed to verify and confirm what the turnout was. And that required, and this is in public knowledge, and it has been confirmed by all the commissioners, that in a number of polling stations, the Kimskit failed, and they, in compliance with the law, they resorted to the printed manual register. The number of voters who voted without being biometrically verified had not been verified and confirmed by the commissioners. In fact, that information was never given to them. The number of voters who had been confirmed as having voted biometrically had not been given to the commissioners. So yes, they cannot change any of the results, but the process of verification and tallying and the constitutional process of determining who has attained the threshold is a joint process by all the commissioners. And that's where they come and say, what is the voter turnout? They confirm that process, because yes, they cannot change anything in the Form 34, even if they see glaring illegalities, they can note them. 2, that transparency required, then they confirm, because this Form 32As are not transmitted electronically. They are brought by this individual, returning officers from the 290 constituencies. There was a possibility. There were some places where voters could not be identified because their biometrics had a problem, and they could not be, and then there was, and that was allowed by the Court of Appeal. The final resort was to resort to the register, the printed register, to confirm that these persons, because they had the IDs were registered voters. That is also a solemn process, because then they confirm, out of all this, were there any other voters that were identified manually, and then that number is verified, so we can come to the determination whether the 50+1 had been attained. They were not allowed to do that. And they requested, it's not that because there was an oversight, they requested and the chairman declined. So this transparency at the National Tallying Center is critical, because as a commission, you have to come and defend the process from the Gazette notice that was issued in January of 2022 to the final declaration. And the fact that the chairman was stubborn is a question, as set out in these 4 affidavits, is that he has contempt not only for his fellow commissioners, but also for the voters and also for the people of this republic, as well as the institutions, because that's exactly what he was told as the chairman, not him as a person, in Maina Kiai, that the chairman of IEBC does not have that role singularly. That is a role vested in the commission. Failure to adhere to a decision that is binding on the commission and the chairman of the commission is contempt not only of the Constitution, but of the institutions, of the judicial institutions that have said this over and over again. And let me go back to the lack of transparency in the process. When you look at the affidavit, which is the most detailed of the vice chairperson of the commission, there was lack of transparency regarding even when the ballot papers came to this country. The chairman calls the vice chairperson the night before the ballot papers are to land here and tells, oh, you are aware that tomorrow we are getting ballot papers. The other commissioners were not aware. This is part of the critical process that was meant to be undertaken by the commission. So transparency is just not at the tallying center, it's about the whole process. Well, if you look at paragraph 8 of vice chairman of the commission, Juliana Cherera, she says, when it came to the issues raised about the voter register that were being addressed in one of the petitions, serious issues had been raised by KPMG. And so that required prompt, because this process was already late, it required a plenary decision on how to address the shortcomings and the lack of integrity of the data in that voter register. The vice chair says they were excluded from that process by the chairperson. So if there was any problem with the voter register, it was meant to be addressed by the commissioners, because they take ownership of the voter register. They were excluded. He made the decision on how to implement the decision and even what to disclose to the public. So these are the processes we're saying transparency and accountability in the whole process, and Article 81 and 86, is just not about the final product that appears on the telly. It's about what the commissioners are meant to do. And lastly, when you look at the affidavit of Commissioner Justice Nyang'ai, if anyone was to be given access to the voter identification, the result transmission system, or the back end, the commissioners needed to know we are giving the following persons access and the following rights, so that if there's any query, they can answer on behalf of the commission. That information was kept away by the commissioners, from the commissioners. In fact, the commissioner in charge of that process. Lack of accountability and lack of transparency. And then these 4 commissioners who are being vilified are expected to come and stand behind the chairman and take ownership of such a process that has so many questions, and then confirm that a person has been declared the president without following due process under the Constitution. They took an oath, and they have a responsibility and a constitutional obligation to the voters and to the people of Kenya not to take part in such a process. And that's what they did on the day of 15th. And that day of 15th is important because if it was the last day, there could have been an explanation as to why the chairman was in a hurry. There was one more extra day. Why was the chairman in a hurry while the choir was singing, the country was peaceful? He had one more day to ensure that the whole process was undertaken in a manner contemplated under the Constitution. And so, my ladies and my lords, we submit that these 4 commissioners, and although they have taken a position here and they've now been they've been sued as respondents, had every right not to give a seal of approval to that process that was not verifiable, it was not accountable, and had not been undertaken in conformity with the Constitution. They respect the work that all the staff at the Commission had done, but they were betrayed by the chairman. Thank you, Chief Justice and judges of the Supreme Court.
Thank you very much. It is now time for the judges to ask any questions or clarifications in regard to the submissions we have heard today. We expect the answers when you will be making a rejoinder. We are not expecting the answers now. It's when you're making the rejoinder. I will start with the Honorable Justice Ouko.
Thank you, Judge President. I have 3 very short clarifications that I want to seek from the team representing the first petitioner. The first one, perhaps I can direct it directly to Senior Counsel James Orengo. What is the relevance of rejected votes when computing the results or the outcome of a vote? The relevance of rejected votes. The second one, I would have addressed it to Ms. Soweto, but the team can deal with it, and you are not answering us today. The postponement of elections in certain areas, and you say this resulted in voter suppression. That people wake up one morning to go and vote for a particular category of candidates, that I go to the voting or polling station to vote for an MCA, or is it called MC? That people go to vote for senator, but not the other positions. Do we have any scientific nexus on this, or is it just an assumption that this happens? The last question for me is on the reliefs that most of the petitioners have sought. Were addressed by Senior Counsel Feroz Noroji and also Senior Counsel Professor Jenda on the reliefs or the relief in Section 80, subsection 4. And I'm wondering, what are some of the elements that must be satisfied before the court can act or can grant the relief under Section 80, subsection 4? That would be all from me, my lady.
Thank you. Justice Renaud.
Thank you very much, Chief Justice. Thank you, Counsel. You've been most helpful to us, particularly to myself. I have 3 questions, 4, I think, but very short ones. The first is to Senior Counsel Philip Murger. You addressed us on the PDF format of the forms, but in the pleadings, there is a JPEG question. Would you like to?
I would like to immediately correct that. It should be JPEG, not PDF.
Oh, okay. So it was JPEG. It was JPEG.
JPEG to CSV.
Okay. Would you then like to connect? Because you addressed us, I think you didn't connect the JPEG to PDF, and then you said CDF.
I will, but I'd just like to clarify that that was a mistake on my part.
Okay. Correct. But just clarify when you answer, so that we can get it right. And also in the context of the staging and tampering and so on, explain to us how that happens in real time. Give us, say, Kagera Primary School Form 34A. What exactly happened in your theory, because you say some of these things you don't have? How was Kagera Primary School interfered with the Form 34A? Number 2, Mr. Arua, and this could also go to the other counsel appearing for the commissioners, you've raised many issues going way back before the election. The Venezuelans, mistreatment by the chairman, we're not allowed to do this and that. But we saw your clients in public reading out results. And that's what I'm calling my acquiescence question. They did all these things until the 11th hour. What evidence do we have that it's not an afterthought, that they're not doing this in good faith? What evidence do we have, apart from the question of the instructions to counsel, the meeting they called? Why do we have anything showing that for the last 3-4 months they documented these grievances and that there was therefore a storm brewing? My own sense of things is that when you come only at the point of final declaration, how then do we trust that in fact there were issues before? Tied to that, what role did violence play at Bomas? Because we have the evidence of the chairman that I couldn't do this because I was attacked, Gulier was attacked, we couldn't announce 27 polling station results, constituency results. What role did violence play at Bomas? I think you need to explain that as the commission, which is what you've said. For Feroz Noroji, Regulation 87.3, you've asked us to declare it unconstitutional, declare it inoperative. Please address that issue in the context of retroactivity and retrospectivity. At the time these things were happening, it was the law. You're telling us to now declare it unconstitutional. What happens to events? And you know what I'm asking about this. Mr. Ndegwa, you made a very innovative, I must say, submission regarding the diaspora vote, the number of constituencies. In answering my question, please go back to Article 89.1. 89.1 says, there shall be 290 constituencies for the purposes of the election of the members of the National Assembly. We are addressing a vote in a presidential election, please connect 89-1 with the presidential election. Otherwise, the way you left it hanging, someone would ask the question, what has this got to do with this court and the petition before us? I thank you, CJ. I thank you, Council.
Yes, let me just take up from where Justice Lenaula has with Mr. Ndwiga. Mr. Ndwiga, if you look at Article 38(2), every citizen has a right to participate in elections. How then do you reconcile that with your argument on Article 89? Because constituencies don't vote, citizens do. So again, prisoners, persons in the diaspora, how are they to be provided for if we are to follow your line of argument? My next question was to Philip Murgo. I was drawing a chart when you explained to us that what you're telling us is that in the evidence that you have is that the Form 34 went into the Kim's kit at the polling station to the constituency. Then between the constituency and the public portal, the Form 38's numbers were changed. They were changed in that sequence, if I'm to understand you. Now, I don't understand much about ICT, but I presume that at the polling station, when the Kim's kit takes the image, these forms are written in handwriting. How can you explain then, so that I can understand, how a form can be changed in handwriting? This is not typing, it's in handwriting. All these forms are being uploaded and changed, different people's handwritings. How does that happen? For Ms. Soweto, she's not here, but since we'll answer later, I was curious about the issue of voter repression and her arguments on that. If we look at the Constitution, Articles 136, 177, 180, each of these elections are separately provided for. So you have the presidential election, which has its qualifications, nomination process, even the dispute resolution process of a presidential election is separate, the governor is separate, the member of parliament is separate, the MCA is separate. And what happens when a voter goes to vote, they get 6 ballots. So it's 6 ballots into 6 ballot boxes. What we have then is 6 different elections, but on the same day. So if your argument is voter repression, then is the voter repression only to the presidential election? Or is that an argument that can be used by an MCA in Kakamega County to say that because the gubernatorial elections were cancelled on that day, my MCA votes have also been affected? Or, I mean, is it just the presidential election that the voter suppression argument is standing for? Or is it all? Because they are all separate elections. So how does one election affect the other? I think those are my questions for now. Thank you.
Thank you. Thank you, Chief Justice. Just a few questions. I think this could go to, I think, Mr. Orengo. You started us off with this elephant in the room, this 50% plus 1. And I've read the submissions, I've read the affidavits. There is something still surrounding this question of voter turnout, the percentage. It's like the beginning of where the controversy is located. What is the relevance of the percentage of voter turnout to determining whether a candidate marshaled the magical number? And then back to Mr. Murgor, this staging. Again, I've been intrigued. I've been reading. If I understood you correctly, and if I understand the affidavits correctly, we are having this Form 34A. The original, which is filled leaves the polling station to go to the National Tallying Center by road, let's say, for ease of understanding, its image leaves to go to the same destination, but this time by air. Somewhere along the line, in mid-air, the image is captured. And then all sorts of things are done before it is re-uploaded, which means, therefore, if you go to that captured image, which has been re-uploaded, you will find different content from what it had at the polling station. So to determine whether that has actually taken place, you would have to go now to the tallying center and locate that one that left by road and compare. Is it possible that that capturing in mid-air also somehow magically changes the content of the one that left by road? Okay, just because I just want to understand. Then let's get back to the 4 commissioners, because this is serious. We were informed by, I think this must have been Mr. Nyamodi, quite graphically, that the 4 commissioners were allocated roles other than those for which they were appointed as commissioners. Some were heads of protocol, I think others were media, welfare. Interesting stuff here, allocating such roles to commissioners. Why didn't they protest? Is this chairperson we are dealing with such a terror that nobody can face him and tell him you can't do this? Because now what we are hearing, these are serious disclosures. Because you can imagine I being, but because I was annoyed by, not annoyed, upset by my friend Willis for having tried to compare. So I'm just wondering, why is it that very serious Kenyans did not seize that chance and protest to the Kenyan people that what we are being given, the roles we are being assigned, have nothing to do with tallying and verification and carrying out our constitutional mandate. I think this is tied to my colleague here, is why to the tail end? Because I'm sure the voter out there also wants to know. So let me leave it at that.
Thank you, Honorable President. I have a few questions, and the first one would refer to the lead petitioner, or rather the main petitioner, the first petitioner, if I may say, in the lead file, which actually initially was petition number 5, E005, Raila Odinga and Martha Karua versus the respondents. And later on, after consolidation, it became the lead file and file number 1. I'm concerned with the reliefs that are sought, the alternative relief sought. The first relief relates to the issue of scrutiny, which is ongoing, and the issue of the threshold, constitutional threshold of 50 plus 1. And after the inquiry, you would like that after the scrutiny, election, and the inquiry on the election technology, all the claims which have been made, and that after there should be nullification of the results, and then an exercise of recount, and after the recount and tally, that the chair be directed to declare the petitioners as the petitioners, that's the 2 petitioners, Raila and Martha Karua to be the successful, or to be the winners of the elections. That's one of the. So I was saying that we would like you to lay a basis, legal basis for this in your rejoinder. No remedy that has been pleaded is going to be taken casually. Every pleading, every relief that we have sought, we are taking it seriously as a court. Therefore, because you will not just do it cosmetically, you must be meaning it. So, is this doable? Is this feasible in law and in all other practical ways? We want justification, and from, I think even suggestions were there in 2017, but now we are here. So I would like you to firm up that and give us, justify the legal basis, the constitutional basis of that, and whether lawfully, constitutionally, that is possible. Of course, we'll be coming to the issue of the capacity, after all the allegations, the capacity of that chair carrying out to be in charge of the exercise of the next process, if you are successful. But before that, okay, there's the alternative that if that's not workable, then a fresh elections take place. Now, that's the problem I'm having is that, and if an election is to be ordered to be done now, yet one of the reliefs you are seeking is that the chair and substantially the commission, but effectively the chair, you want us to hold him or to declare that he is not fit to hold public office because of his malfeasance, because of his the illegalities, irregularities, even allegations of fraud that he has perpetrated, that is not fit to carry out that exercise, to be in charge of such elections. Our Constitution, I believe, has never contemplated and envisaged such a serious situation, such a lacuna. And you know, we are all peaceful, loving people. We believe in the rule of law. We believe in constitutionalism. How is that possible? What are your proposals practically on the ground? If suppose this was done, how do you want us to navigate and apply the law? Is that possible within the law? These are serious issues. These are serious remedies you're asking for. In the meantime, what is the de facto state? What is the status quo? Is that underpinned under the law? These are the questions that we would like to ask, because as you know, in Kenya we have never had a state of emergency, and we all never contemplated, and I don't wish to think about it. Finally, yeah, actually that is all, because the other questions have been asked quite exhaustively by my colleagues. Thank you.
Thank you, Judge President. The challenge one faces when they talk about the same subject at the end of a conversation by many people is that they find themselves repeating issues. But I will still ask what I had noted down during the proceedings, and you can choose the manner in which you will answer them. For Tim Orengo, my concern is, and actually for everyone who has spoken about the commission, what we have heard is what, about this commission, is what some time back we had someone describing, was it an accident or something on TV, and we were told it looked like a video and drama. At least that's how I perceived the submissions on the commission. And so my concern is, when did this commission become this dysfunctional? The effect of becoming that dysfunctional? What corrective measures were attempted, if any, and with what result. My second concern is from 34A. Minor Kiai told us that this election is done not at Bomas, but at the polling station. And for the presidential election, the return of that form is first by electronic transmission. And so, the way I understand it is that a photo would be taken of the form at the polling station. A photo. I want you to tell me whether it's called a photo or what it is called. Is it called a photo? Is it called an image? Is it called what? That's the question I'm asking. And so that time when it is taken, and as it is being sent originally, is it in PDF form? So the journey, because this has to be understood, the journey from the polling station to Bomas, the things that happen in between must be described by the nature of that image at the original place, at the starting point. My other concern, which ought to have followed the first one before this PDF language, is what is to be done as a corrective measure against the chair of this dysfunctional commission. And is it to ignore the constitutional procedures and safeguards that are already in place? My final concern is concerning the relief to declare. What I have heard since morning because of the dysfunctionality of the commission and a few other things is that nearly everything about Articles 81, 86, the Act, have been impugned. In fact, one of you told us that everything that would possibly go wrong went wrong. So if every process that was undertaken in this process has so far been impugned, are we nevertheless to declare a winner? Are the figures, in the event that we arrive at figures that show that either the current president-elect has more votes than others, and or the petitioner in petition number 5, in fact, has more numbers, what are we to do? Are we still to declare? Irrespective of all the other processes having been impugned as you have submitted to us today. If you assist me with some direction in those issues, I shall be in a position to deal with the petitioner's case. We'll see what we will do with the respondents when their time comes. Thank you, Judge President.
Thank you. I think all the questions I had have been asked, but I'd just like to follow up on what Justice Ibrahim asked. The team on the Reid petition, they have been called Team Senior Counsel Orengo. You have asked us to find the chairman culpable of various breaches of the Constitution. And as Judge Ibrahim explained, you have even told us to find that he cannot. Should we find that there should be a repeat election, he cannot preside. My dilemma is, this is a constitution office order. Under Article 251(2) of the Constitution, there is a detailed procedure that is provided for the removal of a constitutional office order. And what I would like you to address us is, how do we go about that? Would we be making an order that is contrary to the Constitution? Because like the judge was explaining, we are a country that believes in the rule of law, in the right of a person to have a reply, to be tried. So, for the breaches that EOC has committed. Mm-hmm. And that is also related to the issues you have also cited about criminal culpability. I want you to address us on, because we have an Election Offences Act, so that if somebody has committed an election offense, they ought to have been charged and tried before the court with the jurisdiction. In this case, I know we gazetted some magistrates to deal with election offenses, and my question is whether we wouldn't be usurping the powers of the magistrates if we have to make any order regarding election offenses. Then to the team led by Senior Counsel Mr. Mwite for the 4 commissioners, I still want to understand at what point the commission ceased to function as a corporate entity. Is it when the 27 constituencies were not announced? Or is it when, I am really trying to understand that, because we saw them announce regularly the results at the plenary in Bomas. We really want to understand, like the Vice President is asking, when did the commission become so dysfunctional? We really want to understand that. Is there a stage where they were working together in tallying and verifying, and then they went and announced, and then suddenly there was a stoppage because the announcements also stopped streaming live? So we really want to understand that. Then my last clarification will go to Mr. Kibe Mungai. And I want you to answer this and tell us how you know that IBC did not make arrangements for certain categories of people to vote, especially the IBC staff. how do you know they did not vote first before they started the exercise? Because they were in a polling station, they could have transferred their vote to the station where they were conducting the exercise and voted. Because this seems quite subjective, so you needed to explain more that 700,000 people did not vote because IMBC did not make arrangements. I think those will be my questions or clarifications that I will be seeking from Council.
Justice, I have one follow-up. May I please on your last question? Section 6 of the IEBC Act, 6.1, says that the chairperson of the commission shall be a person who is qualified to hold the office of judge of the Supreme Court under the Constitution. Then 7A says that the chairperson or member of the commission the office shall become vacant if the holder dies, resigns from office by notice writing to the president, or is removed from office under Chapter 6 or Article 251. In that context, if perchance we were to order removal of Chebukati as chairman, would the commission still be intact with the remaining 6 commissioners without a chairman of that qualification? I'm just wondering for my own sake. Thank you very much, Chief Justice.
I think that brings us to the end of today's proceedings. It was a long day.
With permission, Madam Chief Justice, there is still an issue arising out of the scrutiny. I am told I would like my learned junior to explain, because he's the one covering the technical issue of the scrutiny.
Good evening, my lady, the Chief Justice and the Honorable Judges of the Supreme Court. My name is Eric Gumbo. We've had interaction with my colleagues who are handling the scrutiny, and they give us the indication that there's been very good progress so far, but there's one specific issue which they would want to get clarification from this court on, that arises from order number 2. Specifically, the use of the word forensic image. Now, the applicants appear to be interpreting that to mean an opportunity to get the image of the entire server. Now, that is causing a bit of a concern, because then it means if they have the image of a server, technically, they'll have gotten access to everything that certainly is contained in that server. It means that that order will be so far-reaching that after that event, it may not be possible for the IEBC to use that server again. It then particularly concerns the Commission, because if perchance there was an order for a repeat election and you don't have that infrastructure, it then means that that election may not be conducted. The other concern is the potential breaches that might be in relation to third-party licenses that are contained, and so therefore it really is important that we get clarity on that question so that then the exercise can proceed smoothly. I am most obliged.
Yes, with your permission, Madam Chief Justice, ladies, I raise because after we broke off over lunchtime, I personally went to the IEBC offices, 21st floor, where the exercise was going on. And I'm sorry, but I don't think what my learned friend has said is exactly what was going on. First, the team that was sent by this court to supervise did come up with what was an implementation matrix and laid it out. I think this was done yesterday. And what I learned is the biggest problem that has been going the whole day are arguments about this implementation matrix. And as by the time I left at 3 o'clock, nothing had happened. even some of the simplest issues as giving copies of the technology system security policy had not happened. So what I met is an argument between technical computer people about what they should comply or not comply with, about what forensically, for instance, the issue of the forensic image is not correct that the demand was for an image of the entire server. In fact, what I meant had been agreed on was that the part of the server that was supposed to be forensically imaged was going to be cloned so that there's no access to and that had also been agreed on. But when it came to implementing it, there were always new arguments. And in my estimation, what I found is that there is nobody at IEBC who this order is directed at, who is responsible for ensuring that these matters are done. The CEO of IEBC was there, the director of ICT was there, there were 2 or 3 lawyers from IEBC and a host of other technical people, and all that was happening was arguments happening between one team and another team. The CEO says this, but he doesn't talk, so other tech people come, argue with the people from the political parties. That is the confusion that is going on. And therefore, unless this court addresses its order at a specific person, who then can come in case there is doubt as to what these terms mean, can themselves come for clarification, then that confusion will go on. But either way, we did try to sort out the problems that were there. I left at about 4 o'clock, the process now starting. The advice I give to the team is, let us first see what happens in the several hours, and then they will say what is it they are not getting, and we can report that to court. I will be going there after this to find out how far that has gone. I still feel very strongly that this court needs to make somebody from IEBC responsible for the implementation of this order. Thank you.
My Lord, sorry. Without appearing to belabor the point,
being given an example of one of the issues that arose is because there's also an argument going on as to how many servers are involved. There was talk of only accessing one server, then there's a whole range of technical arguments as to how many servers are involved in an RTS and how many should be shown. Our team is saying that there are about 8 servers involved, that they've only gotten access to 1, that they're not getting access to the other 7. There's nobody at IEBC who takes responsibility to answer that question, so nothing gets done. Thank you.
Sorry, my lady. Sorry, my lady and my ladies and my lords. Without appearing to want to belabor that point too much, I think when we got back after the short break that the court took, Justice Lenola did indicate that there was fairly good progress in all the fronts, both in For Other House and in Anniversary. So it certainly cannot be true what counsel is saying, that there has not been progress, because then that would impute that counsel is even saying that the court is not saying what is happening. We have gotten very clear indications that there's been, there are 4 compliance items that were raised. There were 4 compliance items that were raised. Out of those 4, item number 2 has been resolved, item number 3 has been resolved, item number 4 has been resolved. That is the current update that we are getting from our team. The only item that is outstanding is the question of forensic image. And I think there's substantially good progress. It is not accurate to report that there's no progress. We have our director of ICT who's personally taking charge there and is the one who's updating us on what is happening. I think if we could get a clarification in relation to what that forensic image is, then we will be able to complete the exercise. I'm most obliged.
Thank you, Councillor. I think from what we understood when we took the break for lunch and when we came back, the issue of order number 2 had been resolved, by the question of cloning as opposed to the security question of forensically imaging the server. So what we gathered, and that's what I said when we came from lunch, was that there is progress. Let us revisit it later today after we leave here. But as far as we were concerned, the resolution was that they'll do some cloning, and then any concerns that this team would have would then be presented to us tomorrow, having also gotten a report from our team. But at the time we came, there was good progress, and that's what Mr. Gumbo is saying, so far as we knew from our team out there. So perhaps, CJ, the way to go, let us go back ourselves, perhaps get our report from our team, and should there be any need for a direction tonight, we could do that remotely, and if not, then we give a report in the morning, because we gathered that the progress was immense and that something would be perhaps actually finalized tonight. I think that's the best way to go, instead of us going back and forth. And we don't have a report from our team. So would you allow us to do that? Then we come back to you. Thank you, CJ.
Thank you very much. I think fatigue has settled until even my own gown has tethered me to the seat. I cannot move. But with that clarification, and just to remind ourselves that our team is led by the registrar of the court, who is going to make a report to this court. Counsel Paul Mwangi, I think what you are making to us was a kind of a report. So let us see how we can cooperate and get the best evidence that can assist the court. With that, allow me to wish all of you a good night and look forward to seeing you here tomorrow at 9 when we start the questions will be answered in the rejoinder. Yes, have a very good night.